2020, no matter what new endeavor, but nowhere is it more important to have knowledge and foresight than when your family is about to be dissected by a family court near you. Rarely does anyone come out of a court unscathed. Most of us never did anything wrong before in our lives, and then suddenly you're in a court held to unknown standards, trying to keep your kids from a government agency or vindictive significant other with unrestricted power. Families do not belong in court. Yet, there you are, waiting for a dark stranger to condemn you to a parentless and partial existence. There you are, unable to put Humpty Dumpty back together again. Your life, as you once knew it, is now officially over. The subject today is what you shouldn't do when you're in family court, and I have my friend Gary Jacobs, family law reformer, to help me through this. I have 10 items here for which I think are a hierarchy of things that we should be talking about, but they're not in any particular order. It was a little hard to ascend and descend in terms of the right pattern I would want to put in. But here we go. So Gary, never tell a lawyer you don't care how much it costs is one of the major things you should not do in court.
Yeah.
Why is that?
I think a lot of times people go to a lawyer and you think that your lawyer is going to be your friend and your advocate. And let me tell you, Chris, lawyers are the best salesmen on earth. You talk about a used car salesman, you go to a lawyer.
I had that same thought
They
when I
are
was
just,
doing this.
they know what to say, and you're going in there in an emotional situation, and they know what buttons to push. And if a lot of times we say, you know what, I have to win custody of my kids. I have to get the house. I have to get the car. And I'll do this at any cost. And if I
Spare no expense.
right. If I use up my money, then my parents will give me money, or I'll take a second mortgage. And you will, if you say that. I mean, it will happen. So be very careful, because a lawyer still legally has to give you the best defense. He's not going to do a better job because you're saying that you have more money. He's just going to spend it all. Right. So never tell them that it's endless.
There's no reflection to the money and the quality of the service you get in court.
Absolutely not. There's no correlation.
There we go.
There are many lawyers who are doing this because they actually want to help people. They've gone through, we have a lawyer, Mace Greenfield.
And there are a few, yeah.
And who's been through this, and he wants to help people. So he's not necessarily looking for that. I know Robert Hiltzik is another attorney who's like that, who really wants to help. But some people don't want to hear it.
Yeah, I know. And that's a very tough lesson, but trust us, do not tell your lawyer that there's never any end to the money that you have.
Because there will be an end.
It'll be your end. Okay, number 9 I have in the list is never send incriminating email or voice messages. This is a fairly new phenomenon, I guess the last 10 to 15 years.
Text messages.
Okay, why is that?
Well, a lot of times you're in the heat of the moment and you'll send something that, we always say, you should always write something, then save it till the next day. But when you're mad at somebody, you might write something off, and you may be the greatest person, the greatest wife, the greatest husband, and never done anything like this. All of a sudden, you're in a stressful situation, and the other person knows how to push your buttons because you've been married to them, and they do the thing that pushes your button, and boom, you send that text. And now all of a sudden, the exhibit in every single motion is exhibit number 1, is your nasty text message. The judge sees you for 2 minutes, and that becomes you.
Yeah.
So be very careful about, I say don't send them.
Right.
You should have an attorney that would filter everything that goes to your spouse before you do it. But really be very, very careful. I don't care if you have to put a note on your phone not to do it.
Absolutely. Gag order on your conversation.
Yeah, absolutely.
What people should know also is that you can be transitionally provoked. You can actually move forward, getting and acquiring the language you had from a prior email, and you can actually move more forward accidentally. So you have to be really, really careful about what you put in an email.
All emails will end up in court.
Yep. Okay, number 8, do not believe that the law is good for your family.
I mean, we're all taught to believe that the best interest of the child, and even if you don't go through a divorce, everybody knows that, the law, they say, look, the law is fair, the law is colorblind, the law is gender neutral. There's equal rights between mothers and fathers and men and women. It's absolutely
sounds like a fairy tale to me now.
We know it, but I think as Alec Baldwin said, if you want justice, stay out of the courtroom.
Right.
That's not where you're going to get justice.
There's no question about it. The fact is that law, in family law, can't be so accurate. If you can just live with that concept, that's how do you make accurate a law for you and your kids as opposed to mine and my kids? Yet you can find it someplace codified. Right. But what would make that good for you is a whole other adventure, and that's what it is, an adventure. Law is an adventure, isn't it?
Absolutely.
Okay, number 7, ask for a trial when confronted with supervised visitation. And it has I tied them together with the don't call CPS conversation.
Right.
We had.
I think that's important. A lot of times when you go into a court, there'll be a false allegation of abuse of the children or abuse of the spouse, and the first thing they'll throw at you is, well, if you want to just get this moving, just agree to supervised visitation temporarily, and then we'll get out of it. I say never agree to supervised visitation for several reasons. Number one, that sends a message to your children that they need to be supervised when they're with you because you're a danger.
And no one thinks of that part, by the way.
Right.
You said message to your children.
Message to your children, because alienation happens a lot. And if there's a case where there's a false allegation, there's probably a little bit of alienation that goes along with that too, which is one parent turning the child against the other. This enforces that to say, you know what, mommy's right. Even the court thinks my dad's dangerous, or even the court thinks my mom is dangerous.
You're multiplying the possibilities.
That's number one. Number two, if you ever think you're going to get custody coming out of a supervised visitation situation, then you got to get your head examined, because you will never get custody.
We call that affectionately parenting in a box, because you're actually looked at through a hole in some wall. Am I right?
In my opinion, if you're faced with that, then you tell the judge, no, there is no reason for me to be supervised with my children.
I want a trial.
I want a trial, and if you're going to keep me from my children, take away my constitutional rights to be a parent, I want to go on the record, and I want you to say the reason that you're withholding my children from me on the record. Because a lot of times the judges know they can't do that. So they'll do it in a conference to your attorney. Tell your attorney, no, I want to go on the record, and I want to hear out of that judge's mouth why I cannot see my child.
It can't be said better than he just said it. You have to identify on the record. You have to create,
on the record.
You have to create the record. You don't let them create the record.
They won't create the record.
It won't look good. No matter what they do, it's not going to look good. Asking for a trial is the
an immediate trial, and going from day one and say, if there's
not doing anything else until you evaluate it. Then.
Of course, we're talking about false allegations. If you did something,
you can eliminate
then we're talking about false allegations. You need to go in and say,
or even the idea that somebody wants to give you supervised visitation if there is no allegation.
Right, but usually it comes with an allegation.
Okay,
they'll make an allegation of abuse.
It didn't happen to me, so I don't know.
And then they'll say, well, now we're going to do supervised. It's not a big deal. It'll be temporary. Temporary to me and temporary to you may be two different things. Stay away from it.
Absolutely. Okay, number 6. We don't seek mediation as a source of peaceful negotiation before any litigation, and we should.
Right, absolutely. If you can, it takes two people to make a deal. A lot of times, even in my situation, people would say to me, even family members, why don't you just settle and be done with this, Gary? Move on. But
like as if you had all the control.
It takes two people. It takes two people to do it, and it takes two people who care about their kids, that aren't willing to say, you know what, I don't care if my child has to be examined by CPS, by a forensic psychologist, by a social worker, have to speak to an attorney for the child, have an in-camera interview with the judge. To me, if a parent says that, guess what? They're not a good parent. That should tell the court that parent's not good. A loving parent would say, you know what, let's try to work this out and not go to court, because court is horrible. It's horrible for parents. It should be your
last choice, not your first choice.
It's horrible for children.
Real quick, attached to this number 6 on the mediation in terms of advice, I know I recommend, I'm sure you'll agree with it, you recommend friends and family to converse about their situation first before you go to court.
Right.
Secondarily, go see counseling and see if you can help yourself through that thing.
Right.
And the last decision you should make would be to go see a mediator. You notice that calling for a lawyer is not in that top 3.
Right.
That's the last resort when
but
there's no other option.
They do it first.
They do it the opposite way. So remember that order. You want to see friends and family first, you want to go to a psychological professional second, and you want to go to a mediator third.
Listen, you have nothing to lose going to a mediator.
And then dead silence. No.
Right. I mean, a mediator, they'll almost all give you a free consultation, and they'll tell you how to approach the subject.
They'll give you an idea what the law looks like.
Right. In fact, they may say to you, look, I will call your spouse and tell them that we met, and they would like to do because you may not know how to bring that subject up and explain it. So a lot of times that mediator may go to your spouse for you and say, your wife called me and wants to mediate.
We can collaborate, yes,
and
on issues, on the phone or in caucus, no matter which way we do it. Okay, number 5, thinking that the family laws are fair for everyone. This is something you should avoid.
Big misnomer. I mean, I went into it thinking, hey, 50-50, half the men win, half the women win. It's going to be fair.
Scales of justice.
Right, exactly. When you go in court, you realize you're the father, you are the devil. Now, I'm sure there's women watching this saying, no, this is not true. I've been hurt too. Statistically, the man gets killed in court. Over 90% of men lose custody. Now, they don't lose it at a trial, which is interesting.
Right.
They lose it because they are railroaded into believing that they have no other
De
choice.
facto custodial parent.
Right. So if you look at the statistics, they'll say, well, if you go to trial, a lot of times the father does win. And that's true. But that's why I tell people, if you really want to get custody, don't be scared of a trial. The other person should be scared too.
Right.
So don't be scared.
You place the other person on somewhat of an equal
Right.
footing.
I think at trial, it is more even.
Probably your best opportunity, right?
But when you go to court, they try to railroad you to normally the father giving up his custodial rights as a parent. Don't do it.
Right. Okay. Good advice. Okay. Number 4. Do trust the statement. Do not trust the statement. We have the best interests of your children. I know we partially covered the best interest scenario before, but this is the language that they use. This is the language that they're comfortable with saying.
Rolls right off the tongue.
This is not the reality.
It rolls off. In fact, it rolls off everybody's tongue.
Yeah,
Where
that's right.
The parents will always say, "Oh, we want what's best for our children."
Right.
You know what? The statistics are very clear. You know what's best for a child is having 2 parents in their lives as much as possible. How is it in the best interest to remove a father or a mother and say that parent sees their kid one Wednesday for dinner and every other weekend?
Yeah, that's normal.
That is not in the best interest of a child. So right there, the best interest of the child is off. It's nonsense. There's no such thing as the best interest of the child. But everybody says it.
Yeah, I know.
But it's not true.
It's supposedly the standard that the courts use using that phrase, but in reality, there's never a consequence, especially if you're in family court. There's no consequence to the best interest of child. It's all about acquisition of funds, keeping the system going, the lawyers can make any money.
Punishing the other spouse.
Punishing the other spouse, being alienated, being subject to supervised visitation, orders of protection, false allegations. You can name it from there. It just goes on and on and on. But it never has anything to do with the best interests of children. Please remember that. Okay, number 3, the law guardian is not to be trusted. They do not have, besides my own comment was they don't have the experience with your kids. Remember that. Your kids? How is this person, first of all, he's a lawyer, so he's got some kind of interest and connection with the judge. You should know law guardians have connections with the judges, right?
A lot of times they're actually called attorney for the children now, as you know, we call them law guardians. But a lot of times people think, well, this person will fight for what's best for my child. First of all, it's not even in the rules of what they're supposed to do. Their job is to advocate for what that child wants. And how crazy is this? They tell you when you go to court, the judge will tell you, do not talk about this divorce with your children. Do not put them in the middle of the situation. And when they hire a law guardian, the first thing they do is they say to them, which parent would you like to live with? What pressure to put on children. Yeah. But a lot of times people fall into the false sense of security that this person is there to help them, to say, oh, thank God, I have somebody here who's going to look out for my child. Nonsense. You know what the law guardian's job is, Chris? To make the judge's job easier.
Right.
They know what the judge wants. They lead them on. And they make it easy for that judge to make the decision.
Because you're not aware, the people are not aware that basically the judge really doesn't have a lot of experience with children, and basically law guardians don't have unless they have their own, of course, but they can't really decide for your kids. So the judge can't decide for your kids. The law guardian, what do you call them, attorney for the child, can't decide for your kids. Come on, I ask everybody here, just those consequences alone, those statements alone, how do you trust anybody inside a court to know what's best for your kids? These are your kids, remember. They don't know anything. So be careful about the trust in terms of the attorney for the children. There's a new title?
Yeah, it used to be law guardian, which their role as a law guardian was to advocate for what's best for the child. But going back to what you said, how would they know what's best for your child specifically? And in general, they're attorneys. They're not trained in child psychology. They don't have the investigative tools. They're listening to 2 parents, and they have their own biases, and they bring to the table their own baggage, and they listen to whoever is, in many cases, they can sympathize with that person.
My favorite thing to think about when it comes to the lawyers and judges and the law guardians too, and attorneys for the children, in the court, is that how did they get to be such magnificent, intelligent, and see-through people that they know what your kid needs?
Right.
How'd that happen? How'd they get so good at that? The reason we give too much power to people with authority and positions, and they don't deserve it, and they can't handle it anyway. All right, number 2, do not believe a court is fair and unbiased. The scales of justice are untitled. We went through a little bit of that before. Somehow I mixed the language.
As we said, they absolutely are. You know, it is not fair. The right person or the right person doesn't always, I use win, because there is no winning in the court system, but the better parent doesn't always win. Often it's the parent with more money. Often it's just a luck of the draw that they mesh with the personality of the attorney for the child, or the judge may like.
There's plenty of bias, though.
The judge may like the person, be connected to a person. It's
and
random.
we found that too. We found that some judges will side on one gender side.
Listen, all attorneys
Right?
will say, oh, you have that judge? That judge hates the mother. You
Yeah,
know,
that
that's a
kind of
great
thing.
judge
Yeah,
to
that
get.
kind of thing.
Or you have this judge is horrible against fathers, or this judge hates policemen. This judge hates doctors.
Yeah.
They think they're smarter than
Or
them.
independent contractors.
Whatever it is. But all the lawyers will tell you, which judge has which bias towards, this judge doesn't care about alienation. The judge could care. In fact, they'll help the alienator.
Yeah.
And this judge has no patience for alienation.
They don't have the grasp of it. They
Right.
don't know what it is anyway to begin with. Okay, and the last one on the top 10. By the way, we have a few more, which we have a little bit of time to go through. We will do that too. But I think one of the biggest things that we can teach somebody who's about ready to be divorced or contemplating it, when divorce is imminent, do not sign the stipulation.
That's a big one, and I'm glad that's number one, because you and I hammer that all the time. Do
Yeah.
not sign a stipulation. I'm not saying to never sign it, but be very, very careful, because a lot of times people say, well, the judge said if I go to trial, they told my lawyer in chambers that I'm going to lose. Well, you know what? If you're going to lose, why not go to trial? You get nothing to lose.
Right.
So, but once you do that stipulation, it's nearly impossible to change it. Even if you went to court and got this, listen, they're not going to, if you're going to sign a stipulation giving you one Wednesday for dinner and every other weekend and the maximum amount in child support, why the hell would you sign that?
Right.
Why wouldn't you say, you know what, I'm going to take
not
my
good enough.
shot and go to trial? Because guess what? The worst thing that's going to happen at trial is you're going to get Wednesday dinners every other weekend and the
You
child
can always
support
get
guidelines.
that, in other words.
But then you can appeal it.
Right, which is one of the other ones I'm going to address in a second. But the information on top of not signing the stipulation would be without complete knowledge of what it means to sign it. That's the caveat. I mean, if you had any idea with the complete knowledge of what you do when you do sign something, you wouldn't sign it.
Chris, I mean, how many people have we had on the show even that have said, my lawyer told me it was a good deal, or I just
Yeah.
wanted to get out of this, so I signed it. I didn't really think it, but my lawyer told me I can always go down if I make less money and get a downward modification.
They should know, the audience should know that part of that is an intimidation factor. The judges do that.
All
and
the time.
Lawyers will do that too, and they'll work together with it to keep you, you better do this because the judges are going to like it if you don't
Right.
sign this. This is intimidation, it's coercion, right? Isn't it?
Absolutely. I think,
Yeah.
listen, we sat in courtrooms where the judges said on the record, listen, 95% of people in front of me would sign this
Yeah,
agreement.
that's right. I
Well,
remember that,
That's
yeah.
crazy. You know what? Do be very, and
Because 95% of the people are coerced.
well, listen, you have a
And
judge
they're
sitting at the
intimidated
road,
by
and
the system.
You're intimidated, you're scared. Your lawyer listen, the lawyer is going to appear in front of that judge many times, and if the judge tells him in chambers, look, I want your client to do this, the judges hate making decisions. Number one, it's a lot more work for them, and number two, it can be appealed, and but if you give away your rights, and then you go to court, you say, hey, he gave it away. I didn't take it away.
Yeah.
He had a chance at trial.
There's an opt-out for them, isn't there? Okay, well, we finished with the top 10, but I'm going to give you 3 others to contemplate, to talk about, because we have a little bit of time left in the program. Do not give up because you have lost a motion to the court, or if you lost a position or something like that.
Don't give up is the key. I tell people all the time, they'll say, oh, you know what, I filed 2 motions and I lost, and the judge was horrible. You know what, keep filing them, keep trying. If you're right, your kids are worth fighting for, and you know what, you can file 4 motions, 5 motions. I've had people that have signed 10, 15 motions, and all of a sudden they get 1 motion that the judge says, you know what, I'm going to rule in your favor. That just turned your case around right then.
Right.
So
at any time it could change.
it could change.
Have
Listen,
patience.
I've seen judges who come in one time and just tear the litigant apart, just scream at them. And they go, oh my God, the judge hates me. I'm afraid to go back. And they go back in front of the judge in 6 weeks, and they tear the other person apart. Every day, to me, it's like a roulette spin. When they tell you when you spin the roulette wheel, every spin stands for on its own. Don't go by the last spin. And when you go to court, you remember it because it's your life.
Sure.
The judge just tore 10 other people a new asshole in court. They don't care about you.
That's important. The flavor or the spirit of what happens to you in court can sometimes take you over.
Right.
And can cause you to lose focus on what you need to do. So this is a what to do type of list.
Every court date is different, and I had an attorney once tell me a judge was so biased against me, and the other attorney brought up something that was horrible, and I said, why didn't you fight it? The lawyer, he said, you know what? Because you're mad about it. The next time we go to court, the judge is going to forget about it.
Yeah.
They want it, and it's true. We came to court, and it was a non-issue.
They can't remember. It's too much to do. Okay, 12. You can always appeal any unwanted decision, but the process is laborious and meant to fail.
Right.
So why would I be saying
Well,
that?
again, goes back to the stipulations. You can't appeal a stipulation because you signed it. If you do go to court and you get an order against you, you still can appeal it. Yes, it's expensive, but you know what? I've seen people win appeals that they did them themselves. So you have nothing to lose by writing an appeal yourself.
But there is a low percentage.
There is, absolutely. Okay. It's a biased situation.
We don't want to give people the wrong impression.
No, but listen, first of all, I would always file a complaint against the judge if the judge did something wrong. I would always file a complaint against the lawyer. The Bar Association is a joke. It's a self-regulating agency. It's an old boys club, and they rarely do anything.
What's the name of the agency you call the Center for Judicial Accountability?
Well, in the city, yes, I think that's a government agency, so it's supposed to be legit. I mean, it's really not. They're all friends with each other. But you know what? If they get
Office of Court Administration and Judges,
it's
right?
free. There's no form to fill out. You can send a letter and complain about a judge for free.
And it affects them if you really have a bad experience with the judge. It affects them in the long way. So not filing and not doing that is a mistake, right?
Right. You have nothing to lose. You file a complaint if the judge did something wrong, and don't file it frivolously, of course. But if the judge really did something, you order the transcripts, you document it. If the law guardian did something, you complain to the Bar Association. Same thing for the lawyer. And an appeal, as I said, you can go to agencies. There are nonprofits. Americans for Legal Reform is one that would give you some guidance. They can't give legal advice, but they can say, here's where you can go to the website, go to this website, and you can do an appeal yourself as a layman.
Right.
I'm not saying this, the odds are great.
You can get also help from Americans for Legal Reform in terms of pro se advocates and also
right, they can hook you up with some of the pro se
things like that.
Right.
Okay. Last on the list. Okay. Never be alone with your soon-to-be ex. Make sure you record it. Okay. Tell me about this.
I mean, I try to tell people all the time, and unfortunately, this is something that nobody listens to till the first incident happens. But a lot of times, going through a contentious divorce, your spouse may try to set you up to say something or to do something. These orders of protection. A lot of times, people know how to push your buttons. I say never be alone with the person, never have a telephone conversation with the person. Always, always record it. I know in my case, it kept me out of jail, and it kept me from being removed from my children in the long term. Short term I was, but I had a recording that proved my innocence. In New York State...
Yeah, I was going to say, you're going to have to show us how.
Yeah, in New York State, it's legal for one person who's in the conversation to record it. So I couldn't record you talking to somebody else, but if I'm talking to you without your consent, I can record it. And what you would do is a lot of times people say, well, you can't use it, it's not admissible in court. It absolutely is admissible. And the way you get it into court, okay. And this is in family court when you're representing yourself. You take the recording in and the other lawyer will object and say, well, we never had it in advance. We don't know if it's a real recording. What you do is you say, I'd like it marked as an exhibit for identification purposes. Then you play the tape and you ask the other person, after I play this tape, tell me if you believe this is a true recording of what happened, or if you felt it's been tampered with.
Your opposition at that point.
Your opposition, right?
Okay.
You ask, and then they have to say at one point, well, I think it's not real. At this point, I never really said this.
And the judge stop him from listening to that.
But once it's on the record, you know what? The judge heard it.
That it's evidence.
It's part of the record. It may not be.
That's all.
If the other person says no, that's not really what happened. He edited out the whole part where he did X, Y, Z. But the judges aren't stupid. It's usually obvious that's a flowing conversation. But at least you have something. In many cases, just the fact that your spouse knows that you have it would be enough to end up, but you need to protect yourself. Many people end up with false orders of protection, and it's very, they say innocent until proven guilty. In family court, they don't really go by that. They go by, well, we think it sort of happened, but, it's not, there's no evidence. You know what? Push it to a trial and say, I want evidence. You need to be able to defend yourself.
Right, and you need as much information that you can work with, because you're going to have the deck.
How do you prove something didn't happen?
Stacked against you.
You can't prove something didn't happen if you don't have something. Always have, listen, we have them on cell phones now. If you have an iPhone, you download the app, you turn it on, it'll record in your pocket for 12 hours. Nothing happens that day, you delete it and you record it.
Start again.
It's no big deal. It's not like you have a tape recorder.
You charge the phone, you're all set.
Like I actually say record when you're with CPS.
Yeah.
If they send you to a court-ordered mediator, absolutely record. There's a nightmare of a woman that's supposedly a mediator in Suffolk County Family Court. Her name is Jean Marie Massetti. Do not talk to this woman unless you have a recording on.
Yeah.
She is a biased woman.
We've seen this. We've seen people do this, and by the way, it really does help. And hopefully, we've gotten that one woman fired from that case I did last month. You may remember that. Anyway, Purple Lady, we call her. But what a tremendously sad situation you have when when CPS or a judge, or somebody's behind the scenes, talks the stream of the judge will decide, the judge knows, the judge is king, whatever.
And listen, they do lie. Do not believe that somebody who's an officer of the court, for example, this Jean Marie Massetti, she will absolutely lie and say that somebody said something that they didn't to get across her agenda.
That's scary.
And I know it for a fact, and we're saying it on TV. So
Yeah.
she can come after me if she thinks I can't prove it, but she absolutely will lie.
In our final minute here or so, how would you just say in a nutshell, because we ran through everything, what's the most important? You want to have your own pecking order, like signing a stipulation? I think we agree
I
is the
think
most
signing,
important.
we agree, is the most. We see it all the time. People consenting to something. If you didn't do something, do not consent to it. Do not. If you didn't hit your spouse, don't consent to an order of protection, because they'll tell you, listen, it's not admitting guilt. You're just consenting to this, but it doesn't mean you're guilty.
Right.
But it'll be used for you the rest of your life. It'll be used against you.
In terms of what else you can do, I think the second thing is asking for a trial if you're confronted with a supervised visitation. I think is
Go
also
for the
very
trial.
important. Go for it.
Go for it.
These
Supervised
are
visitation
things you can do.
is not being a parent. Sometimes people will say, and the judges even said it, you know what, it's better than nothing. No, it's not better than nothing. It's ruining your relationship
I like
with
the way
your child.
they try and talk into things. You said something before about them being a salesperson. They are the best.
Right, absolutely.
Very unfortunate. And something else we should mention is that seeking mediation is absolutely a way to step away from all this nonsense. Of course, there's no guarantee you're going to settle, but the success rate in mediation is very high. You have a very good chance of succeeding. Gary, thank you very much. The program went along very well. I hope that people heed the warning. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.
Properly inflating my tires burns less fuel and saves me money on gas. Yeah, I'm saving Mother Nature from pollution, but more importantly, she saved me $11. Ow!
Environmental defense. Get green.
By keeping my car regularly tuned, I save money on gas and repairs. That also means cleaner air. Feels good to help save the cash, planet.
Environmental defense. Get green. For more tips, go to getgreen.com.
Introducing the all-new Enclave. It's a minivan to the max, with features like remote control sliding rear doors, 150 cable channels, a full sky view roof, temperature-controlled cup holders, and the 6-point navigation system. It's the minivan for families on the go.